In my column today on the ABI website, we report a very interesting decision from the 11th Circuit, where the Court of Appeals went through all kinds of contortions to avoid following a decision from the U.S. Supreme Court in 2016 known as Husky versus Ritz. Husky was a 7-1 opinion written for the court by Justice Sonia Sotomayor. In that opinion, she gave an expansive reading to the words in the statute obtained by fraud, with the result that, in more cases, debts will not be discharged in an individual's Chapter 11 case if there was fraud afoot. The case in the 11th Circuit was factually different because, let's face it, cases are almost always factually different. And the 11th Circuit, as a result, latched on to those factual differences to distinguish Husky and not to, shall we say, end up with the same result as Husky. In this 11th Circuit decision, the Court of Appeals said that, in fact, the debt was discharged, even though there was massive fraud that was afoot in the case. As I read the 11th Circuit opinion, those three judges were, shall we say, uncomfortable with the manner in which the Supreme Court may have departed from the plain language of the statute. Well, I'll tell you what, I'm not going to say who's right and who's wrong. This is a very interesting subject. Should there be policy made by the courts, or should courts adhere rigidly to the language of the statute? If you're interested in this kind of a question, or Supreme Court lore generally, I'd say first read my column, then read the 11th Circuit decision, then go back and read the Supreme Court's Husky decision, and form your own judgment about what the law either is or should be. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting that has occurred in the world of bankruptcy. Until then, be well, stay safe, stay home, and we'll see you same time next week. Good day.